Hi, I'm Lee Phillips. I'm an attorney, actually counselor with the Supreme Court of the United States. I'm going to talk to you for 2 or 3 seconds about how a living revocable trust avoids probate. The fact of the matter is everybody gets their living revocable trust to avoid probate. But 95% of the people who get a living revocable trust do not avoid probate. They go through probate just like everybody else does. They may have a good trust, the actual legal document, but the problem is the lawyer never teaches them how to use the trust. In the early 80s, my father-in-law spent equivalent to today's dollars of about $8,500, and he got a nice living revocable trust. But when I got out of law school and I started to look at it, I looked at it and I found out it wouldn't have done him any good because the lawyer hadn't taught him how to use it. Now, my father-in-law, he sat there and he argued with me. No, my lawyer taught me how to use the trust. No, they never teach you how to use the trust. It's a conflict of interest. Look, if they don't teach you how to use the trust, then they get the big bucks for setting up the trust, and when you die, they get all of the probate too. It's a double dip. The living revocable trust has to own the property if it's going to avoid probate. We say that it has to be funded. That means it has to own the stocks, bonds, cars, house, boats, everything. I'm going to teach you how to get everything in because you can't just even if the lawyer does it for you, it isn't going to work half the time. It's been 10 or 15 years ago. A lady comes into my office. She sits down. What's happened is her husband has died that year. Now, she and her husband have been living in the rest home. There's no house, there's no cars, there's no nothing. All they have, or all this lady has, is $100,000 in treasury bonds. And she's been to the local banker and lawyer, and they said, man, lady, you don't want to go through probate with these bonds. You want a living revocable trust. So they gave her a simple, single living revocable trust. Then this banker and lawyer, they were brilliant. They said, okay, we know how to handle this. The way you get, the trust has to own the bonds if it's going to avoid probate. The way you get the trust to own the bonds is you sell the bonds and you buy them back in the name of the trust. What did they do? 50 years of interest clocks. There's no tax until you sell the bonds. She paid $32,000 in income taxes that year, and there wasn't a thing I could do about it. The idiot banker and lawyer, they didn't know. All you do is you go to the Federal Reserve Bank, you get the form, you fill it out, and they change the name on the bonds. No tax. So somebody's got to sit you down and teach you step by step how to move the stocks, the bonds, the cars, the house, the boats, everything into the trust. If the trust owns the assets, here's the trick. Probate amounts to getting a court order so that somebody else can sign a dead person's name. If your name's on the deed and you're dead, family sells the house. They show up at the title company and the title company says, okay, where's dad, where's mom? We need them to sign the deed. And you say, well, mom, dad, dead. And the title company says, okay, where's the court order? Where's the court order that says who has authority to sign the deed on mom and dad's behalf? They're dead. And this whole process of probate, you have to go to court. You have to prove that it's mom and dad's real will. You got to go to court. You got to prove mom and dad didn't owe anybody money. This whole process is called probate. When you've done all of this proof, then the judge issues what's called literally a letters testamentary. And yeah, it is plural. Letters testamentary. And that gives whoever the judge says the power to go down to the title company and sign the deed. So the trick is, if we mom and dad transfer the property into the trust now before they die, then when they die, the owner of the property didn't die. The trust is the owner of the property. The managers of the trust died. And in the written document, it says who the next manager is. So what we do is we take mom and dad's death certificate down to the title company. We take the trust. We take the deed, which says the property is owned by the trust. The title company reads the trust, and they'll actually take a copy of it and file it, so we know we've got good chain of title. And it says when mom and dad are dead, oldest son signs the deed. So oldest son signs the deed in front of the title company, and we've sold the house. We transferred authority before mom and dad died. That's the trick to avoiding probate. I don't care if you've got a piece of paper, a living revocable trust. If you don't have the property actually owned by the trust, it doesn't make any difference. It isn't going to do you any good. So you've got to go through, make sure that you learn how to use the trust. I prepare audio CDs, I do all sorts of stuff to teach my people, my clients, my students, how to actually use the trust. And we have to go in and teach you how to move each one of the assets in. It's not hard. Anybody can do it. You can do it. But somebody's got to sit you down and teach you how to do it. And you can't afford to pay the lawyer to do that for you. So as a result, like I say, 90-95% of the trusts don't work. Can you see the trick? Once you know the trick, you can make it work. Somebody's just got to sit you down and teach you how. And I'm happy to do that.